Hello everyone and welcome to the Career Choice Series webinar on copyright law. The Career Choice Series is designed to give law students, young lawyers, and transitioning attorneys a general overview of a practice area and ways to position yourself to get there. The Career Choice Series is brought to you by the ABA Career Center Law Student Division and Young Lawyers Division. The Young Lawyers Division is here to help new lawyers navigate the early years of their career and law students prepare for life after law school. The Law Student Division offers premium benefits, which includes access and savings for Quibi.com, discounts on bar review programs, up to $50 off West Academic casebooks, and a legal ethics bundle that includes a free Model Rules of Professional Conduct ebook. Upgrade to premium for $25 at abaforlawstudents.com/go-premium. The ABA Career Center offers both career development resources and a job board for law students and legal professionals across all disciplines and career stages. Moderating our program today is ABA Career Center board member Karen Britton. Karen is the Assistant Dean for Admissions at the University of South Carolina School of Law. Prior to joining USC, she served as the Senior Administrator overseeing student recruitment, admissions, strategic enrollment planning, diversity recruitment, scholarships, financial aid, employment services, and student career development at the University Tennessee College of Law. You can read a bit more about Karen on the PowerPoint, and that's available for download now and on our website. And moving forward, we'll let Karen introduce today's panelists.
Thank you, Lexi. We are so pleased to have two experienced and knowledgeable panelists to discuss careers in copyright law today. You should see their bios on the screen, but I want to add just a bit more context for you. Dave Rein's firm, Erickson Kernell, is a boutique IP firm of 10 attorneys with 4 offices located in Kansas, North Carolina, and Colorado. He is an experienced IP litigator who is now focusing on advising and counseling individuals and companies on a full range of copyright and trademark issues. His firm bio says he works with clients in industries including manufacturing, technology, architecture, the visual arts, food processing, and energy. Dave was a judicial clerk right out of law school at Iowa. His firm bio suggests that he finds creative solutions for his clients, which certainly is an important competency for anyone wanting to be successful in IP law. Tiffany Schwartz is in the Kansas City location of Dentons, the world's largest law firm with 175 offices or portals that connect legal talent across regions in 78 countries, and I can't tell you how many lawyers. It's no surprise that a law firm this large is also diverse culturally and organizationally, known for tapping new technology and managing client needs in innovative ways. Their Next Law Labs is an example of their innovative approach to client services that is fascinating to read about, I think. Tiffany, could you start the conversation by giving us an overview of copyright law practice in general and your practice in particular?
I'd be happy to. Thanks, Karen. So I have a very broad intellectual property practice. I don't do patent work and I don't do litigation, but almost everything else that falls under the umbrella of intellectual property is something that I've touched on or I do regularly. And I know we have a lot of students joining today, so I thought it might be helpful to take just a few seconds. Hopefully I can do this in less than a minute, and kind of give a vocabulary lesson of sorts. So what is intellectual property? What comes under it? So intellectual property, or IP, is a kind of an umbrella term that refers to various categories of intangible property. So it's everything not covered by your real property class. Patents, trademarks, and copyrights are probably the things that you're most familiar with, but IP also covers things, trade secrets, know-how. A number of other categories of information also get lumped into IP, like confidential or proprietary information, customer lists, price lists, and even software sometimes. I'll try to stay out of the weeds too much and just kind of look at those 3 main categories, give you some background there. So patents protect inventions. In my mind, because I don't do patent work, I kind of think of this as gadgets and gizmos and methods of doing things. But generally, we're talking about, an inventor has invented something new and novel and useful, and the patent is what protects that. Trademarks protect brands. So a brand can be a logo, a name, product packaging, product design, even the look and feel of the interior of a store. So think of an Apple store or a Starbucks. A brand or a trademark is anything that tells you the source of a good or service. So when you see that Nike swoosh or the Starbucks green label, you know who's providing the shoe that swoosh is on or the coffee that's in the cup. Copyrights, and what we're talking about today, protects the expression of an idea. You may think of books or photographs, but it also covers art, software code, architectural designs, jewelry designs. You'll often hear the phrase, the tangible fixation of an idea. And that may be a little bit confusing, but basically it separates the idea from that expression that we're talking about. So the example that I use when I teach this subject is I talk about my son and I sitting in a park, and we both paint a picture of the same tree. We can't protect the idea of that tree. Any one of you could come and paint this and sit in front of that tree and paint your own picture of the tree. But each of my son and I get copyrights in our respective paintings of that tree. 3 thoughts to throw in here on copyright is that copyright protection doesn't require registration. As soon as my son and I finish our painting, we own copyrights in that painting. When we talk about copyrights, we're talking about several different rights. So that S on the end, when I say copyrights, is what we refer to as a bundle of rights. It's the right to reproduce, to publicly display a piece of work, to publicly perform if we're talking about a song or a movie, to make derivative works from. So if you own the rights in a book, you're the one that owns, unless you've licensed or sold them, you're the one that owns the rights to have that book made into a movie or have that book translated into another language. So this is all just kind of a broad overview background to get us to where we're talking about today. You know, to the extent that my practice covers copyright, I do a lot of other things outside of copyright. And part of that is that I'm located in the Midwest and have always been in the Midwest. It's hard to be a pure copyright lawyer in the Midwest. And I think Dave has a somewhat similar background there. So our practices may be a little bit more diverse. If you're on one of the coasts, there may be there may be an opportunity for you to focus more on copyright and have more of your day in, day out be purely copyright. But you know, my practice covers trademark, covers software, covers a lot of licensing, both on the copyright side and on other IP sides. So I'll let Dave jump in there and see if he has anything to add kind of on that overview of the practice kind of topic.
No, that was a great overview. The only thing I would add is if people are interested in learning a little bit more about what copyright is and what it isn't, copyright.gov, that website, say what you want about the government, that website does have a lot of good information, frequently asked questions. I typically will send new clients there. I'll give them homework, ask them to go through some of the tutorials, and there's just a wealth of information there. My practice is similar to Tiffany's, with the one exception that I also do litigation. But I agree, if you're in the Midwest, there are very few people that focus solely on copyright, and they tend to be more in the publishing and media industry, but then of course you get a lot of First Amendment issues as well. But that's not to say that there isn't plenty of copyright work to be done outside of the coast, or some of you might also refer to us as flyover country. The good thing for you if you are in the Midwest is that there aren't a lot of people focused on copyright issues, and it is not something that you just dive into and give it the old college try. There are enough pitfalls out there where it's you do want to know something about copyright before you just jump into it.
Dave, why don't you tell us just a little bit about your career path, how you got to your current position, and then we'll ask Tiffany to do the same.
Oh, no, thank you. Well, I did not get into the traditional way. I started as a federal judicial law clerk, joined a large law firm, and was in the commercial litigation section. So I was litigating mergers, acquisitions, securities, all that stuff that might make some people's eyes glaze over and others jump up with glee. But our practice area was fairly new, and at some point as they started growing, they asked me to join them. And slowly but surely, I ended up now where I focus exclusively on intellectual property issues, and it's rare that I'm involved in a commercial litigation case. In fact, our firm is a boutique firm, so we don't do anything other than intellectual property. But one of the ways that I got involved, and maybe this is for a later question, but is also doing some volunteering. So there's volunteer lawyers and accountants for the arts in just about every major and many secondary cities, in terms of size anyway, not in terms of quality, of course. And that's a great way to get involved in breaking into this area, and I'm sure we'll talk a little bit more about some of that. But just the networking and volunteering, reading, and then slowly but surely getting involved. And frankly, one of the ways I got the attention of the intellectual property group was I did go to them and say, I'm interested in this. And so that's another way to get involved by just letting people know in your firm that this is something you're interested in. And if you need to write off the time, you'll, not write down the time, but you're interested in getting involved. And at some point you'll become that expert.
Tiffany, tell us a little bit about your career path and how you got to your current position.
Happy to. So I had a little bit of an unusual start as well. I, after undergrad, took a year off before going to law school, and I was fairly confident I wanted to go to law school, but I decided to take a position at a law firm as a secretary in the interim, just to kind of get an idea of what life inside a law firm was like. I had worked as a legal secretary during high school at a very small town law firm, traffic tickets and minor criminal work, and we maybe represented like the water district or something. So, it was a very different kind of law than I knew I was headed towards. So I took a job at a law firm. I was in St. Louis at the time, and as a secretary, and the secretarial manager called me after she had hired me, and she said, we've decided to assign you to the intellectual property group, told me who I'd be working for. And I immediately went to my computer and searched intellectual property because I had no idea what that phrase meant. So I started there as a secretary and moved into a paralegal position after about 6 months there, and then decided I did want to go ahead and go to law school. So I applied to law schools, and one of the schools in St. Louis at the time, SLU, had a night program. So I decided to do their night program and continue working. So I worked in the IP group of the law firm throughout law school, first as a paralegal, going to law school at night part-time, and then I switched and went to law school full-time while working as what they called a law clerk, which was kind of a full-time summer associate position. So I was doing really lawyer level work as a second and third year law student. The other interesting thing about the law firm that I was at the time was I was the second attorney hired in the IP group that did not have a patent license. So the IP group was the result of a merger with a local boutique firm that required that every attorney they hired be a patent attorney. So me and another woman who did not have a patent license tended to get handed any kind of work that came into the department that was not patent and wasn't litigation. So I got this very diverse introduction to intellectual property and everything that I kind of refer to as the fringe work of IP. So I learned about domain names and domain name disputes and filing UDRPs and online agreements and website terms of use and privacy policies, anti-counterfeiting software licensing, all of those they're almost IP, but not quite, but they don't fit anywhere else in a full service law firm. So these two people that are in the IP group that don't do patent work, we'll give it to them. So that's kind of how I got to where I am with the breadth of my practice.
Tiffany, I bet if you described a typical day for you now, it would be somewhat different at such a large firm. Tell us a little bit about a typical day on the job for you. And then, Dave, we'll ask you to do the same.
Sure. So I think the thing that stands out for me is that there are no 2 days that are the same. Sometimes I look at my calendar and I look at the week and I think, okay, so Monday and Wednesday, I'm going to spend my entire day on the phone, whether that's working on calls or working on agreements, negotiating agreement, dealing with the trademark examiners at the trademark office. I also spend a lot of time presenting, doing things like this presentation, also presenting CLEs, either with my firm or outside of the firm. One of the things that I love about the practice of law is counseling and educating. So, where I now have sophisticated clients and spend a lot less of my time kind of doing the basics of IP and strategy with them because they've been through it all before. I kind of redirect that to doing CLEs and presentations. Also, IP, I think, is one of the most fun topics to present on because everything that we present and talk about in those presentations is relatable to the audience at large. We get to talk about trademark disputes. Anheuser-Busch is getting sued over the corn syrup Super Bowl commercial. We get to talk about the U.S. Postal Service using a photo of the Statue of Liberty on a stamp without realizing that the photo was actually of the replica statue in Vegas instead of the real Statue of Liberty in New York, and the implications of that from a copyright law perspective. So, getting to be kind of on top of those, what are kind of pop culture issues, but they bring in all of the areas of my practice, is one of the things that, I really enjoy about the practice and kind of collecting those and getting to present on them. The other thing with working at a big firm, and I don't know if this differs for Dave, is I work with a large team of people. So I work with partners in New York and Chicago. I have a paralegal and a secretary in the Kansas City office with me who handle most of my trademark prosecution work for me. But then, I may work with an associate in Dallas or some of our associates in California on different cases. So I get to spend a lot of time figuring out time zones and working on, how do I make this team of people across the country, how do I bring them together to get a project done for a client? So.
And Dave, you went from a larger firm to a smaller firm. Tell us a little bit about how a day in your life might be even better now than it was, or what a day in your life is like.
Well, I tell you, since we're out here in Colorado, we don't talk about Anheuser-Busch. We refer to Coors and the craft brewery companies. But other than that, a lot of the things that Tiffany has already described, it would be true. Just to focus it a little bit more on the copyright side of things itself. One of the reasons that I think copyright law is so important in the practice, whether you're going to be a litigator or you're going to just be a pure transactional person or some hybrid of that, is copyright works its way into almost everything. So, for example, I was working on an agreement. There's a celebrity involved, and you have rights of publicity issues, but you also have a lot of copyright issues that are very important to be able to make sure that those are covered in the agreement. And sometimes when I'm reviewing a contract, I'll see that most of the I's are dotted and T's are crossed, but there's some issues with the copyright that the folks really haven't considered. And being able to bring that to the table, I think, is very important. But, Tiffany mentioned that copyright law covers a huge area. It does go beyond, books and movies, but software issues are always very important. Every city seems to want to be the next tech hub. And so having some understanding of copyright law is also very important in those pieces. I am in a smaller firm, so I used to be at one point, but I'm not dealing with multiple offices. But one of the things that we traditionally do work with is we get involved in a lot of cases that maybe didn't start out as an intellectual property case. It might have started out, for example, as an employment case. And then someone knocks on our door and says, hey, would you help us out by being co-counsel on this litigation? Because now there's issues about intellectual property that we're just not really equipped to handle. And so we'll jump in on some of those issues as well. But like Tiffany said, it really isn't one day is going to be this. One day maybe I'm going to be in a deposition. The next thing I'm working on a license agreement. And from a copyright point of view, that's kind of fun, frankly, especially when you get to see something that you worked on translated into something that your kids can relate to, which is always fun.
Yeah. Well, it's clear that both of you enjoy what you do, but let's talk a little bit more about likes and dislikes. There has to be some challenges that you both face. So, Dave, tell us a little bit about that element of your daily work.
So one of the challenges is just to tie back to one of the earlier comments that Tiffany made. She's made so many good points, and that is that while a lot of the work is done on the coast, that presents a challenge and an opportunity. The challenge is that you're probably not going to be working on the latest blockbuster movie, but there are quite a number of different documentaries that are being filmed in the Midwest. I think a lot of states have passed laws or funded different efforts to get the film industry into, for example, Kansas City and Denver areas. And so there's lots of opportunities to work on clearing issues and copyrights that way. And if you can set yourself up as that person who understands these things, then maybe it doesn't have to go to someone out on the coast who's going to charge $1,000 an hour. Maybe that gives you an opportunity, but it also presents a challenge because there aren't as obvious obvious opportunities in the copyright out there. The thing I absolutely just love is, frankly, figuring out a problem that's going to help people succeed. And I don't know if that's because my wife tells me I should have been a teacher at the beginning of my career instead of a lawyer, although the law seems to have played out very well and I've enjoyed it. But just seeing our clients succeed it just makes me happy, right? It makes me want to work harder for them, especially when you've started with them at the startup stage and you've seen them grow, you've seen their challenges, you've played some, even if it's a small role, in getting them through those problems. And when they succeed, hopefully you get rewarded, but you also get to see and be involved with all the exciting projects that they're doing from the ground up. And I really love that piece of it. Tiffany, I think you probably have some other ideas as well.
Sure. So kind of tagging onto one of them that you said, I think one of the really interesting things in copyright law is the clearance issues. So you talked about, like clearing for movies or films, just for the audience. And, is someone who may not have that experience, things to think about are, you've got a shot in a film that maybe shows, a street in Kansas City, for instance, and there's street art on one of the walls. Somebody has to think about, does someone own that street art? Can we show it in this film? What are the rights around that street art? How do we, if we do feel like we need to get consent from the artist, how do we find the artist? And so it's that creative problem solving, and it's risk management, but it's also thinking one step ahead. So that's one of the things that I love, and just kind of thinking through, in this shot, what could someone complain about, or what could someone object to? And one of the other things that I love about my practice, and I always have, is that it's helped me, especially as I feel like I get older and my kid gets older, to stay at the forefront of technology, because my practice requires me to understand how new technology works, whether that's software, the direction that advertising and marketing is going into branded content, and understanding how content is shared and how advertisers and marketers use different technology platforms in different ways for advertising. I recently did an analysis for a client where they were trying to figure out when they could use photos of celebrities that were wearing their clothing. And they were specifically doing an IPO in Europe or the European equivalent of an IPO, and they needed to produce materials for potential investors. And the question was, we gifted X piece of clothing to celebrity. There's a photo on Instagram taken by third-party photographer that shows celebrity wearing our coat. Can we include that photo? And how can we include the photo? And who do we need rights from in order to include the photo? And, just all of those pieces and working together in that creative problem solving are things that I love. I would say one of the challenges to the practice is also the technology and keeping up with it and how everything works together and making sure that I'm up on, what's the latest platform that's coming out, and where are things going, and how are my clients going to use this, and how are other people going to use it to infringe my clients' rights.
Tiffany, could you tell us just a little bit about the skills that you think are really critical to success? And then Dave, will ask the same of you.
Sure. So I think my top two, the first I would call being creatively practical. And that's, it's understanding your client and the issues and finding that practical solution that gets them to a business resolution that works. What you quickly learn in practice is that being legally right doesn't help anyone if it doesn't let the business succeed. And that ties in with, what Dave was saying earlier about, it's enjoyable to be part of the team that helps your client succeed. So when I can come up with a really creative solution that gets the client where they need to be and either, saves money, saves effort, makes it more efficient, that's a good day for me. And I think that really comes up in contract drafting, also in negotiation, and being able to see both sides and what both sides need to find that meeting of the minds in the middle and move forward, and being able to draft one. And I think one of the most important skills for me is writing skills, and part of that is because I do a lot of licensing and contract drafting, but I think it's also understanding whether you're reading statutes, whether you're reading case law, or you're reading agreements, it's being able to read and quickly comprehend and then put into practice, what you've digested.
Dave, do you have critical skills you would add to Tiffany's list?
Well, I would echo and emphasize the very first one that she mentioned, and it's one of the things that was driven home to me when I joined a smaller firm. It's great to work for a large law firm who has huge clients who have larger budgets. They always have budget issues, but tend to have less of an issue with the money side of things. So thinking creatively to be able to accomplish a task in advising your client, and yes, you could do this, but here's all the different issues you have to get through. I think whether it's in intellectual property or any kind of law, I think is extremely helpful. And it's much more critical when you're dealing with startups who have limited funds. Everybody has limited funds, but you especially have limited funds when you're doing these startups and you're going to your venture capital people and trying to explain why you're going to have to spend $10,000 on X, Y, or Z. The problem solving is certainly a part of it, and that's true of everything as well. Picking up what Tiffany was saying about technology, this is an area where if you want to jump into copyright law, or even if you are already in it, you have to want to learn, because this is not a static area. The whole disruption economy and all those buzz phrases that we kind of roll our eyes over because we hear them too much is extremely true in copyright law. Everything, we have laws that go back to 1909, last updates in the 90s, and a lot has happened in the last 20 years in trying to figure out how does that new thing or new way of doing business or new way of thinking about things, how does that change all the different ways that we've traditionally thought about copyright law and how do we pigeonhole those different things. So this is an area where you really have to have a passion and a want to continue to learn, because this is not a static area, which is cool, right? I mean, you're not bored. It's the challenge is being able to advise your clients in some way to say there are unknowns, but this is the way I think we should go, and here are your risk and here's your rewards. And so it's kind of fun that way, but it's challenges and opportunities continually.
Well, let's talk about some surprises in your practice. Tiffany, do you mind telling us a little bit about what you believe that people would be surprised to know about working in copyright law?
I think some of these we've probably touched on a little bit, so they may be less of a surprise at the end of this presentation than they were at the beginning. But I would say the division of copyrights. So even if you're familiar with trademarks and patents, typically in those cases you're dealing with, maybe one or even two owners. For copyrights, their rights can be divided in such a way that, if we look at how music rights are divided, someone owns the rights in the lyrics, somebody owns the rights in a sound recording as it's been recorded by a certain artist. Oftentimes, the right to license that piece of music is owned by one of the licensing agencies. You may have heard of ASCAP or BMI. So those rights get separated in such a way that it's not a matter of going to one person and saying, hey, can I use X? I mean, it may be a matter of going to the licensing agency and saying, can I use X? But in a lot of cases, it's a matter of figuring out which rights you actually need in order to do what you want, and then figuring out who owns that right to the work that you're talking about. I would say another surprise is that, in most of my practice, when I'm dealing with copyrights, I'm not dealing with books or music or even movies. I'm dealing with social media content. I'm dealing with photographs. The rights of publicity issue that overlays copyright is very common, and rights of privacy that overlay it. And I would say that's probably my third idea around things that are surprising is how copyrights interact with other rights. So, you may have copyrights that overlap with design patent rights, or you may have copyrights, for instance, in an intricate logo that's been drawn that then also becomes a logo at a brand and gets registered as a trademark later. So that overlap of how the different intellectual property rights work together, and the strategic way in which you can use them to build on one another and create broader protections around your client's intellectual property is something that's interesting and surprising, perhaps.
And Dave, tell us about some surprises that you've encountered.
Maybe the surprise is the way I'm going to try and answer this question, and that is I recently was talking to someone who told me a story, and I'll relay a shortened version of it. And that is, there's this person who's having a dream at night while he's sleeping, obviously, and he's dreaming everything in threes, three llamas, 3 webinars, 3 everything. And when he goes to work, he's assigned a 3rd task on the agenda. He's asked to go to Washington, D.C. on the 3rd of the month, and he goes through his day. Everything again is 3s, and so he says, wow, I'm going to the racetrack. So after work, he goes to the racetrack. He walks up to the 3rd window, places his bet on the 3rd horse of the 3rd race, reaches in his pocket, finds he has $33.33, so that's how much he bets. And at the final turn, there are 3 horses that are grouped together. His horse is winning, and when they announced the winners, naturally his horse came in 4th. And that's exactly how sometimes copyright law is that we think of things in terms of common sense, and they'll take us so far, but then we find common sense will really hose us at times, which is a surprise because copyright law is based on statutory law. We go to the statutes, we're trying to parse things, the judges are trying to parse the statute, and so we think of that it should be fairly straightforward. But then when we come to issues about ownership and what is publication? My gosh, you could put your kids through college just on the issue of what is publication. Fair use, damages. We think about damages in a lot of different ways. And those are, frankly, surprises to a lot of people. And it works in our favor sometimes when we know a little bit more about copyright law than the person who's just dabbling on the side. We had a temporary restraining order hearing in federal court recently, and we were able to win on the issue of ownership. And I will tell you that our defense was a huge surprise to the other side, because they just frankly didn't see that copyright law treats ownership differently and defines who is the owner of something much differently than we do when we think of in terms of trademark, patent law, or just straight up property law. So I would just say the surprise is that copyright law seems to be very straightforward, and it is to a point, but there are so many areas where you can get tripped up that you can use that to your advantage if you're willing to put in the time to work on it.
We're going to ask.
Oh, sorry, Karen. I would actually add one more in there, and that's, thinking about our audience today and how many students are in the audience. I think there's a common misconception that plagiarism and copyright infringement are the same thing. And, so I would say maybe to a student, it might be a surprise that, citing a source doesn't get you around copyright infringement. So they're two different concepts, and understanding the difference between those concepts is something that, doesn't usually come about until you're outside of academia and get beyond, kind of the rules of plagiarism. So.
No, that's great, Tiffany. Thank you for that. Before we ask Dave and then Tiffany to talk a little bit about their involvement in the ABA and perhaps how that has been an influential force in their own career development, I'd like to remind our audience that they can type in any questions that they would like to have our panelists answer, and we'll field those questions from the audience right after we hear just a little bit about your ABA involvement. And Dave, why don't we start with you?
So if you are a law student, or I believe first year out, and I'm not sure how far out that they define this, but the good news is the American Bar Association is free. And I would very much encourage people to take advantage of it, because not only is your membership free, but you're entitled to join several of the sections. So that's really how you're going to get involved. I made the mistake when I first joined the American Bar Association many years ago, and I was not involved. I was pretty much just sitting on the sidelines, and the magazine is fine, well enough, but I don't know that you're going to get enough out of it unless you get involved. And when I was ready to make that commitment, I found that there's a whole wealth of resources that just come with that naturally. So, for example, by being a part of the intellectual property section, you're regularly working with, or have the opportunity to work with, frankly, the rock stars in the area. You can work with J.K. Rowling's U.S. copyright lawyer. You can work with some of the best trademark attorneys in the country. Same goes with patent law, if that's the area. Obviously, we're focusing here on copyright law, and that's where my focus has been with the intellectual property section of the American Bar Association as well. But it's gotten me to not only be able to meet and get to know some of these lawyers, but now I feel very comfortable where if I have, for example, a publishing question, I can call a friend of mine who all he does is publishing issues, and I can say, this is what I'm thinking about doing. Is this a bad idea or not? And he'll tell me yes, no, or have you thought about doing something differently? Also being part of the different sections will allow you, especially as a law student, to really get involved. And so when you're talking to potential employers, or if you're going to make a lateral move to somewhere else, you can have some additional experiences that you can talk about. So, for example, if the Copyright Office regularly asks for comments about some topic, hey, what do you think if we changed the damage calculation? Or what do you think about having a small claims forum? Because litigation is ridiculously expensive, and if you're a photographer and someone ripped off your 5 images, you may not have enough wherewithal to go to court, but maybe a small claims court. And those are all things that you can work on right away. Or if you go join a committee within the copyright section and you say, you know what, I'm really interested in this. Be careful when you say that, because we will embrace you and say, great, what do you need to run with this, or how can we help you achieve that? So it's a fantastic way to get involved. And if you decide the American Bar Association isn't for you, there's the Copyright Society as well. Again, more active on the coast, but even here out in the Rocky Mountain chapter, we have events pretty regularly. And I also recommend that people get very involved at the local level too. Get to know some of your lawyers that are there in whatever town that you want to work in or are working in. And between those two networks, you can find a way to get involved. And I already mentioned the Volunteer Lawyers and Accountants for the Arts is a great way. There's also many organizations that are looking for help on intellectual property issues out here in Denver. There's something called Mi Casa. Entrepreneurs tend to be Hispanic, but really from all walks of life and from every ethnicity come asking for help. And it's a great way to give back and frankly learn a little something too while you're at it.
Well, I think you were clairvoyant, Dave, because the first question that we received just talked about, apparently you guys made your work sound so appealing that the questions want to know what resources are available for young attorneys in particular who would like to know how to break into doing copyright law if perhaps they haven't worked in that area before. So you've mentioned, Dave, some additional resources for networking and connecting, but perhaps for breaking in. Any suggestions for either of you on that direction?
If I could hog the time as well just a little bit. The American Bar Association also has, I was not involved in it, but I've worked with the Young Lawyers section, and it's probably one of the most dynamic and energized groups, whether it's in the intellectual property section or ABA as a whole. And I will tell you, if you show an interest and energy in the area, they'll fast track you to as far high to the highest level that you want to go to. And that's probably true in most of these organizations. But as far as breaking in, I think going to whoever, if you're working in a law firm or you're working in-house, to let whoever you're reporting to know, hey, I'm interested in doing more of this work, and I'm willing to eat my time or do whatever it is to start getting some of these projects, and also get out there and volunteer, and then get involved in these different bar associations and volunteer organizations. And I think you'll be able to piece together something slowly but surely.
We've had another question, and I think this is for both of you, about how you manage to balance your time with such a busy practice and also be so involved in your communities and in bar work. And a proverbial concern, especially for new lawyers, young lawyers who are trying to make those difficult calls. This may need to be the last question that we take, but I wondered if both of you could speak to that just a bit.
Sure, Dave, you want me to go first on this one?
Please.
Being perfectly honest, this is a constant challenge, and I don't think that, figuring out how to balance the challenges of a busy practice and family and friends and still doing the self-care things that we all want to do, that challenge never goes away. I had a saying when my son was a baby. And, you know, honestly, he's 8 years old and I still kind of live by this. And it's that it doesn't matter where or when we sleep, just that everybody sleeps. So it's being flexible. So, you know, if that means, you know, somebody's sleeping in the family room and 2 people are in one of the bedrooms, then that's how we sleep for that night or that week or that month. And I think I kind of take that same approach to practice. And one of the great things about, you know, being in private practice, and especially at a larger law firm, is that I have a lot of autonomy. I can work when working works for me, and I can take the time away when I need to. So that may mean that I'm sending emails out at 1 o'clock in the morning, but I spent the afternoon picking my son up from school and going to baseball practice and getting a run in while it was still warm and sunny outside. And then after my son went back to sleep, I went back to work and, you know, put in a few hours at night. I've always been a night owl, so, you know, 1 o'clock in the morning means nothing to me. It really means that I'm energized and ready to get things done. You know, for someone else, that may mean that, you know, getting up at 5 a.m. In fact, I work with a partner who is frequently online at 4 a.m. I sent him my memo at 1:30 this morning and said, you know, I'll check in with you early in the afternoon, but if you want to make some progress on this while you're, you know, at your prime time between 4 and 8 a.m., go for it. I'll be doing other things. So, you know, I think being flexible and, you know, figuring out the schedule that works for you and lets you get in all of the things that are important to you. One of the best tips that I've been told is to make sure that you schedule the things that are important to you first. So I've recently started keeping a paper planner again because I found that I tend to just ignore the Outlook calendar because there's too many things on it. So the really important things go on the paper calendar. My running schedule is already in the calendar for the next 6 weeks. My kids' school schedule stuff is in the calendar for the next 6 weeks. Work stuff goes in 1 week at a time. So, you know, I think putting in the big rocks into the jar first and then filling in with the smaller stuff and figuring out what's a big rock for you and what's a small rock for you.
That's great, Tiffany. Dave, do you have anything to add to that before we turn it back over to Lexi?
I don't. In fact, I think I was taking notes on that last one.
I think we all were. Thank you both. I think it's been a great presentation today, Lexi. We will turn it over to you to wrap up.
Awesome. Thank you, everyone. As our housekeeping notes at the end, we'd like to thank Karen for moderating the program, and a huge thank you to Dave and Tiffany for joining us and sharing their insights. The conversation was incredibly dynamic and well thought out, and I'm confident our attendees will really appreciate it. And thank you to everyone for attending today's program. If you like programs like this, we have 2 webinar series upcoming in the Career Choice series, is how to litigate civil sexual assault cases in the Me Too era, and that will be on Friday, April 26th. In our Career Development Series program, we have a couple coming up, starting with Optimizing Lawyer Brain on April 12th. So you can stay tuned to our programs by connecting with us on social media. We're a little bit across the board all over. We'll post program updates on our channels and any other relevant information. And then lastly, to get to know Karen and other members of the board a little bit better, you can check out our leadership page. Our website is ambar.org/careers, or you can put the full one in, americanbar.org/career-center. Thank you again, everyone. And then before you go, we would appreciate it if you completed our short survey. It helps us with future programming. Have a great weekend.